Hello, everyone, and welcome to tonight's program. Before we begin, our event today is hosted by Fraser Valley Regional Library, and we would like to begin by acknowledging the land on which we gather and our libraries provide service is the shared traditional territory of the Coast Salish and Inkleklaatmus people. So thank you for joining us tonight. Tonight we're joined with Emma from the Tenant Resource and Advisory Centre, and she's going to be talking about tenant rights and responsibilities in BC. This presentation will be recorded, but we will end the recording when the Q&A starts. So during the presentation, we're going to keep everyone muted just to limit background noise. And then at the end, we will turn the recording off to have a Q&A. At the end of the presentation, I will also send a link to a feedback survey. We really welcome your thoughts, and I encourage you to fill it out if you have time. So I will pass it over to Emma. Thank you so much for joining us.
Thank you. Good night, everyone. Thank you for having us. Thank you to the library that has put in this program tonight. We are glad to speak about tenants and landlords' right responsibilities under residential tenancy law in British Columbia. So tonight, we start by talking about acknowledging the land, because TRAC is located on unceded Coast Salish territory, including the lands belonging to the Musqueam, Squamish, and Tsleil-Waututh Nation. Tonight, we are grateful that we have given sort of a unceded permission to be on the lands, but we are here and we are happy to share the information with you. Okay, TRAC is a nonprofit center that provides information, education, research, and advocacy on residential tenancy matters. Our mission is to promote and enhance the legal protection of tenants in BC. And with that in mind, then we move on to the services TRAC offers. TRAC staffs an information line on Mondays, Tuesdays, Thursdays, and Fridays from 1 to 5. On Wednesdays, tonight, we are open from 5:30 to 8:30 p.m. So if any of you have any calls or have been trying to get through during the day and you did not get an answer, it's because we only start the service at 5:30. Now, our service is only provided in English. We don't have capacity for other languages. I do speak Spanish and French, but I normally assist only people in Spanish because French is not a popular language in BC. And so other than that, services are in English. Now, the tenant information line answer questions regarding to evictions, repairs, security deposit returns, dispute resolution questions, and more. We are not in any manner associated with the residential tenancy branch, as the RTB is the government office that deals with both landlords and tenants. At TRAC, we only assist renters. So if you are a landlord, I will excuse myself. I will not address your questions. At TRAC, we also offer a full representation program, but I would like to give you the heads up on this one. As a TRAC, we only have 2 legal advocates and 2 lawyers. So we are mostly at capacity all the time, but we work with local advocacies. In Abbotsford, there is Abbotsford Community Services that now I think it's called Archway Community Services. So if you are a tenant in Abbotsford or in Mission, you might want to reach out to them first, as they are the local advocate in that area or in those areas. The full representation program consists of going to the residential tenancy branch hearings for you. Our services are free of charge, but you must be making 40,000 to 45 combined if you want to come to us. When you come to us, you have to come to us with a hearing date. If you don't have a hearing date, don't try our service. Most services will ask you to have a hearing date so that we can see the deadlines and see if our advocates can get involved. I emphasize, TRAC is a very small center. We are made up of 11 people only for the whole province. So we are almost always at capacity. So that's why I'm referring to Archway Community Services if you are in the catchment area of Abbotsford and Mission. Now, at TRAC, we also offer workshops in-person workshops and webinars like this. Our aim is also to educate tenants about the rights and responsibilities under residential tenancy law. We also publish the Tenant Survival Guide online. We used to print them, but we don't have any funding, and nobody wants to give us money to do that. As printing it is a little bit difficult in the sense that we have to update a lot of information constantly. And so then a lot of funders don't want to spend money on that anymore. And then that made us create a link on Wikibook, and that is where you can access the Tenant Survival Guide. We have an excellent website as well that you can explore further. You can find almost anything regarding your tenancy at the beginning, during, and at the end of the tenancy. There are also enforcing monetary orders, enforcing evictions, illegal lockouts, other way tenancies, and so on. So it's a very useful place. And we also have frequently asked questions, where you can find a lot of answers that can help you resolve your matter without even calling us or without even calling the residential tenancy branch. We have presence in social media. We have X, Facebook, and Instagram. And we also offer an online course called Renting It Right, where you can get a certificate at the end, and you have to do it at your own time and on your own pace. So it's a really useful, and it has 3 parts. First part talks about finding housing. As all of us know, as first-time class tenants, that it is difficult for us to secure housing because there is practically no housing in BC, and the little housing there is pretty pricey for most of us. Then that's the first part, finding housing, then rights and responsibilities, and dispute resolution systems. And then from then on, we also do systemic advocacy. What that means is that TRAC can go to the residential tenancy branch and bring issues or tendencies we have identified on the telephone that seem to be problematic for renters in BC. Then we pass them on as a concern, and then they'll have to figure something out. So for example, one of the tendencies right now is that landlords are evicting tenants at no fault. That is a 2-month notice for landlord's use of property. Tenants, for example, are saying, my landlord is evicting me. I have lived here 5 years. I don't know how he can do that. Unfortunately, they are able to do that. But again, there are penalties for landlords who are evicting in bad faith. You could also read on our website. Okay, so we're going to teach you about the basics of residential tenancy law. Residential tenancy law in BC is expressed through the Residential Tenancy Act, the regulations, the Manufactured Home Park Tenancy Acts and the regulations, rules of procedures, and policy guidelines. It's about the tenants and landlords' rights and responsibilities, so it is always good to double check with the RTB about a specific piece of evidence based on the Residential Tenancy Act, or you can call us. If you are a renter, please don't call the Residential Tenancy Office. You will be wasting your time. They will still send you to us. So instead of calling them, call us directly. Now, tenancy laws in BC are different than tenancy laws in other parts of the world. What that means is no matter where you come from, if you come from Europe or Central America, South America, North America, and then you come to live in BC, the rules from any part of the world do not apply here. Even if you come from within Canada, the rules from other provinces do not apply here. So the basics of residential tenancy law also teach us about tenancy agreements, the importance of tenancy agreements, and tenancy agreements not avoiding or contracting out of the RTA. What that means is that the landlord cannot include unreasonable requests in a contract. For example, a landlord cannot include that the tenant is only allowed to have a guest for 15 days only. That totally contradicts the legislation, because the legislation does allow for tenants to have guests under reasonable circumstances, even for overnight accommodation of guests. Tenancy agreements cannot include unconscionable terms that are oppressive or grossly unfair. Again, this is along the lines of contracting out or avoiding the act. So for example, if a landlord includes in a contract, and this contract has an addendum, which is extra pages on the contract, and they state, At the end of the contract, the landlord is going to keep the security deposit. That is going to go against the legislation because landlords are not allowed to include terms that are oppressive or grossly unfair to the tenant. All tenants have the right to get their deposit back, and that deposit is always related to doing an inspection at the beginning, and that is the obligation of the landlord, providing you with two opportunities, doing the inspection, providing you with documents, and do a final inspection as well. Now, the tenant is responsible for any damage beyond normal wear and tear. What that means is that if you cause any damages, your landlord isn't going to pay for the damage you caused. So you'll be the one taking care of that damage before you move out. We also teach you about jurisdiction in this webinar. Jurisdiction is mostly about coverage. Are you protected under residential tenancy law? Are you covered? As not everyone who rents their home is considered a tenant under Residential Tenancy Act. And this is clearly stated on Section 4 of the Residential Tenancy Act that talks about not being a tenant under the RTA if you share a kitchen or a bathroom with the owner of the property, or even if you rent from another tenant. We call them a head tenant whose name is on the contract. The contract belongs to that specific person. That person asks for consent to rent rooms. Landlord gives them consent. The landlord has nothing to do with the person who comes to rent from the tenant. So if you rent from another tenant with whom you live as their occupant or roommate, you are not protected under residential tenancy law, but your legal recourse is the Civil Resolution Tribunal that handles non-residential tenancy act disputes. There are other instances, such as if you are a tenant who lives in cooperative housing. Cooperative housing has its own act, so the Residential Tenancy Act does not apply. Student housing provided by your school, for example, the University of the Fraser Valley, they may offer housing, or they may try to make accommodations and contracts with local owners, or anybody who would be able to offer a place for an international student. And so those do not apply if the agreement is made directly with the school. Vacation or travel accommodation, hotels, or Airbnbs. Emergency shelter or transitional housing if you're coming out of a bad relationship, abuse, domestic abuse, whether a woman or a man, then if you're going to an emergency shelter or transitional housing, you are not protected. Housing-based health facility that provides hospitality support services and personal health care. We see this type of setting mostly on seniors. And so other people that are sick and require house chores, so they're not covered under the act. They're under supportive housing. Living accommodation made in the course of providing rehabilitative or therapeutic treatment of services. This is for people who are in a hospital or who are staying for a specific period of time. 3 months to 6 months doesn't mean that it is a legal housing situation. And so again, some of these are covered under Civil Resolution Tribunal, but mostly Bullet 1 and Bullet 2. Share a kitchen or bathroom with the owner of the property, or rent from another tenant with whom you live as their occupant and roommate. Ahead, I will address the issue of occupancy. Occupancy is only a living arrangement. So the fact that you sign a contract with a renter doesn't mean that it is legal and that you are a legal renter in BC. So please be aware. The Residential Tenancy Branch, also known as the RTB, is a department of provincial government in charge of residential tenancy law. They offer different services, and they are open from 9 to 4. They offer an information line for landlords and tenants between 9 to 4. They may have the capacity for other languages, so you would have to reach out. If you are a tenant, we ask you to call us instead. Even though we don't have other capacity than English and Spanish, we can only assist you in those two languages. Then the Residential Tenancy Branch might be probably able to have capacity in other languages. They offer the info line, 9 to 4, Monday through Fridays. They have an excellent website where you can find videos, dispute resolution information, dispute information to apply. You can also find forms. You can also find scenarios. You can also find links to other places that can answer your questions. You can also find past decisions that can help you educate yourself before you start applying and make a case against a specific situation. They are located in the city of Burnaby, and that's the only office in all BC. There are no other offices other than the one in Burnaby. If you live in Abbotsford and you want to put documents through the residential tenancy branch, you might want to try the Service BC office that are centers that connect to extensions of government offices, including the RTB. The residential tenancy branch also is in charge of the dispute resolution process, what that happens between tenants and landlords. So whenever a tenant or a landlord are having serious problems with the tenant and the landlord are not understanding each other, then the landlord is just following illegal or doing illegal situations against the tenant and vice versa, you can definitely go to the residential tenancy branch and use a dispute resolution process to resolve your issue. The dispute resolution process is done over the phone, and it's similar to court, but almost always done over the phone. And so that means that you could also ask for in-person hearings. So it would be up to the residential tenancy branch. Normally they grant them if you have a disability or if you don't speak a specific language, and then you don't have any other support other than get the help of an advocate to represent you, and you have to procure yourself your translator. The residential tenancy branch does not pay for any translation services. That would be at the cost of the landlord and the tenant. So you have to procure your own translator or interpreter if you are granted a face-to-face hearing. If you also have a disability, that also may be accommodated by the residential tenancy branch. Okay, an arbitrator is the legal person, the decision maker who makes a legally binding decision, similar to a judge. If you want to use a dispute resolution system, you have to pay $100. If you are low income, you may want to try a fee waiver, trying to prove that you are low income and the fee might be waived. The residential tenancy branch has specific requirements for a fee waiver, so I invite you to visit the residential tenancy website and read a little bit more. When you use a dispute resolution process, you need to have evidence, not simply allegations, because we normally tell tenants on the phone when they call us on the information line that if they are looking to make evidence, they need to be really sharp about creating it, not too much, not too little, but just the right amount. As a lot of arbitrators don't like, for example, to read 200 pages, 200 photos, and etc. Right? So in our experience, you have to condense the evidence so that it is easily readable for the arbitrators plus the other parties, which in this case would be the tenant and the landlord and anybody who is involved in the process. So for example, just saying I have a lot of evidence doesn't make a good case, but rather having the proper evidence that is going to reflect exactly what your problem is. Now, if you don't have any evidence, there are ways to go around that, but not because you want to go around it, but because the law allows it. You may create an affidavit, which is a sworn legal declaration where you can tell your story, even though you don't have enough evidence to support it. Then you can tell your story, and that may be accepted as evidence in your case. So other than that, photographs, receipt, witnesses, letters, any documents between you and your landlord. Sometimes arbitrators accept text messages and emails. So you have to be careful as well because there are specific requirements on emails and text messages. So at the end of the day, it is up to the arbitrator to accept them or not. And at TRAC, we normally tell you that if you have signed document RTB 51, you might be able to get away with email service. But if you didn't sign it, but that is the only way you communicate with your landlord, acknowledgement is very important. Acknowledging means that the landlord or you, the renter, admit that you have received something and say, thank you, yes, I have received it. That would be enough evidence, and then it can be considered evidence by an arbitrator. Then we also teach you about tenancy agreements. This is also a very important part. If you decide to go for dispute resolution, a tenancy agreement will always tell you all details regarding your tenancy, your name, legal names of the landlord, the type of tenancy you are in, if you are allowed to have a pet, how much rent you're paying, how much of a security deposit you are paying, and all the rules, and if there is an addendum. So a legal contract between a tenant and a landlord is always good to have. Even though verbal tenancies are still covered under the Act, we strongly recommend having a written tenancy agreement. It is best to be protected that way. A tenancy agreement would also tell us the type of tenancy, whether you may be on a month-to-month from the very beginning, or if you're going to go on a contract and then later turn into a month-to-month. As you can see from here, you may start in letter A, you may start on a month-to-month. You don't necessarily have to start a contract. And this is an agreement done between the landlord and the tenant. B, you start on a contract and then continue on a specific periodic basis. Those periodic bases can be weekly, bi-weekly, or other, which in this case, it can be one month to month, or it can be a license to occupy. And then it's for a fixed term ending on. That means it's a contract for a specific date, and it ends on that specific date stated in those little boxes. D, at this time, the tenancy will continue on a month-to-month basis. You started on a contract, and now you can either go month to month or you can go on another contract. And the last one is letter E, which is a vacate clause that are only allowed in limited circumstances under Section 13.1 of the Residential Tenancy Act. A landlord can only use this box you see here to write two reasons only. One, the tenant is on a sublet, and at the end of the tenancy, they will return the contract to the main renter. Or two, the landlord is going to occupy the unit. And so the landlord should put the proper section here and initial. So if they put any other random reasons that are not contemplated under Section 13.1, it's not enforceable. And then the key landlord contact information is also key to provide to the renters, as it may be necessary for a dispute resolution issue, or it may also be necessary for any contact information you want to pass on. The legislation clearly states that the landlords must give tenants a copy within 21 days. And this is a signed copy. It's not just, here, I filled it out, here's your copy. It needs to be signed by the landlord, okay? They also include how much the rent is going to be, what is included in the rent, if you're going to be using a car, how many cars you have the chance to park, and if you have free parking, etc. So whatever the landlord checks off, you have to read your contract to understand what you can and cannot do. When you are a renter in BC, if you are a renter for the first time, then you might want to read this document that is called Disclosure of Personal Information. You will find things such as, is my landlord allowed to install a camera in front of my unit? The answer to that is they need your consent. They cannot unilaterally install a camera and get away with it. So that's under the Privacy Commissioner's rules. Also, another common question we get on the phone is my landlord allowed to ask for my SIN number? The answer is they may sometimes in certain situations. Is my landlord allowed to do a criminal check if the landlord suspects that there is something wrong with that tenant applying for it, or the tenant is just very shady and trying to avoid giving proper information? Then the landlord is allowed to do it. And stuff like that is what you can find in this document. The host tonight has received a list of resources that she may share with you. Not sure how, but I imagine it would be via email. And then we quickly move on the type of tenant you may be. Occupants and roommates are ruled out, not covered under the Residential Tenancy Act. So that only leaves us with co-tenants and tenants in common. Now, you will hate this information, especially about co-tenants. This is a very common scenario in Abbotsford. Co-tenants are people who are on the same tenancy agreement and are jointly responsible. Two friends from school move in together, but one of them wants to move out, and that would have the effect to terminate the tenancy for the other. And there is no way under the law that the landlord is going to allow you to stay unless they want to do it and they don't want to give you a hard time, which is very rare. So in a co-tenancy, both names in the contract, one of them wants to move out, then that has the effect to terminate the tenancy. But if the landlord allows the tenant to stay, they are very likely to offer a new contract at a higher rent. Tenants are not happy with that, and so they would prefer to move out. You can also read policy guideline number 13 about the rights and responsibilities of co-tenants for you to have an in-depth understanding on what you could be up against. Tenants in common, it's much better. It's individual different tenancy agreements. You are individually responsible. So those two friends from university or school, each of them has their own tenancy agreement. So the other one who wants to move out can move out whenever because they have an individual tenancy agreement. They can do it and they won't affect the other person. So probably that's a much better choice for friends. Normally, I consider that co-tenancies can also work better with family members instead of friends. So, but that is my point of view only. You can choose to do whatever you want to. Deposits and fees. This is money tenants pay at the beginning of the tenancy. Normally, in BC, a security deposit is paid to secure the unit. Even without signing a contract, the moment you put down a security deposit, that kind of seals the deal. So you have to pay half a month rent and you cannot back out of it. If you decide to back out of it, then that is going to affect your tenancy greatly because say, for example, that you are going to pay $1,300 for rent. Then you have put down $650 security deposit. But then you found a different place for less than $1,300, and then you found a place at $1,000. And now you want to move out, but you have already put down that security deposit. The landlord is under no obligation to return it to you. Because under Section 7, the person who does not comply with the tenancy agreement, and I mentioned this before, even if you haven't signed one, you have put down a security deposit, and that kind of seals the deal. The landlord and the tenant are entering in the understanding that the place is going to be taken by that tenant. And now the tenant changes his or her mind, so now the landlord will be able to keep that money. And then the tenant is going to be pretty angry because they won't get that money back, but the tenant changed their mind, so the landlord is allowed to keep that money under residential tenancy law if they claim Section 7 of the Act that talks about a person who doesn't comply with the Act or the tenancy agreement has to mitigate the other for the loss, right? So this is information that is useful before you start renting. So in other words, if you put down a security deposit, don't change your mind. If you do, you will lose that money. The same goes for a pet damage deposit. It's half a month rent, and this is the power of the landlord. The landlord may say no, the landlord may say yes to a pet. They are allowed to say the type of pet you may have. They are allowed to say the size of the pet. So it's always good to double check with the landlord, don't sneak one pet in, especially if the landlord clearly said no pets. If you sneak one pet in, you should have consent in writing from the landlord, and there should be also an inspection before you bring your pet. If you just sneak it in, you could be evicted with a 1 month notice for cause because you are not following the rules the landlord set out. Okay. All security deposits and pet damage deposits belong to the tenant. Landlords don't have an automatic right to keep this money, and they are not allowed to state in a contract as an additional term, as in an addendum, that they will keep the money at the end. A landlord is not allowed to put in something like, I automatically would keep that money. And I mentioned this at the beginning. This is related to doing an inspection at the beginning and at the end of the tenancy, and the tenant must participate. And so since 2009 up to 2022, there was 0.0% of the deposit interest calculator. That means that your landlord intakes the deposit and then he keeps that money in trust there, and then he has to return it if there are no damages after doing the final inspection. And then you get a little bit of money. But as I said before, since 2009 up to 2022, the deposit calculator was at 0.0%. It restarted last year in 2023 at 1.95%, and this year at 2.7%. Application fees are illegal. It means that under Section 15 of the Residential Tenancy Act, a landlord cannot charge for investigating your suitability as a tenant. They cannot say, oh, you have to pay me $75. It is refundable if you are not accepted. Even if you are accepted, they don't have to charge you for applying. Okay, no guest fees, even for overnight accommodation of visitors. You're allowed to accommodate a friend or a visitor in your unit, and the landlord cannot limit that because landlords cannot restrict guests from accessing a tenant's rental unit under reasonable circumstances. Now, be careful with this because I know this as I staff the information line and I get calls from Abbotsford and tenants are like, my girlfriend moved in with me. And is she allowed to stay with me? The answer to that would be you need to check your contract and you need to see what conditions the landlord may have laid out in the contract. But I don't have a tenancy agreement, so you will still need to ask permission to get your girlfriend become an occupant. So normally you'll have to refer to your contract to find out what kind of conditions the landlord laid out for you and possibly for a possible occupant. Non-refundable fees are monies that landlords don't have to refund to tenants, especially if you have lost a key, you want additional keys or replacements. There are circumstances where there are fees charged by a strata corporation to the owner of the unit. And so those are normally called move in and move out fees. Sometimes it is maintenance fees. So you have to read your contract and you also have to follow Form K, which would be the rules of the strata. So it's key that you remember that information because just signing and securing a place may result to be a big headache for you. Also, the legislation, Residential Tenancy Regulation, Section 7, allows for a fee from $15 to $25 for late payment of rent of the return of a tenant's check by a financial institution if those terms are included in the tenancy agreement. And then we go back to the tenancy agreement and we remind you to always check your contracts because sometimes we only check the parts that we think are important but don't read the whole document, and that's totally fine. But just if you find that there is an addendum, read that addendum. An addendum may be important because if it is included in an addendum, it may be enforceable. So for example, a landlord may say, the tenant hereby agrees to carry insurance. You go and carry insurance because that's what the addendum is asking you. Your landlord has clearly said you must carry it. So you have to be careful with that as well. Okay. And then circumstances or situations such as liability insurance, personal belongings insurance, and displacement insurance are the types of insurance a landlord can potentially ask a tenant to carry. But remember, they must be on the tenancy agreement for it to be legal. I have been talking about the inspection report. I mentioned it twice. And this is the part that I talk about the obligation of both the tenants and the landlords to do an inspection. Mostly, this is the landlord's obligation to do together with the tenant. The landlord has two obligations. One, to offer two opportunities to the tenant to do the inspection. And two, to fill out the form and give a copy to the tenant. What is the tenant's responsibilities? The tenant's responsibilities is to accept one or the second proposal of the landlord. If they cannot meet on the first time, then they have to go for a second time and accommodate that. And two, receive copies of the documents. And three, give a forwarding address in writing on the move-out inspection report on the day they move out so that the landlord has 15 days to return the security deposit to you. There are consequences for both if the report is not met. Okay, so for example, if the landlord does not offer two opportunities, does a visual inspection, and the tenant takes video and takes photos, and then the landlord says, oh no, it's fine, it's okay, you can move out, and then later on tries to say that he filled out a report by himself, that will go against him, because the legislation clearly says that the landlord must offer two opportunities to the tenant. If the tenant cannot meet one or the second, then they can assign or give the landlord a person that is going to represent them. So if the tenant doesn't participate, the tenant may also be in danger of losing that security deposit or pet damage as well. We quickly move on to your rights, and this is a very important right and also very difficult to prove. It is called quiet enjoyment. All tenants in BC are supposed to be free from unreasonable disturbances, including smoke, noise, intimidation, and harassment. And I would like to remind you that every city has a smoke bylaw. So for example, it is known by all tenants in BC that tenants are not allowed to smoke in the balcony, inside the unit, on common areas, and in the hall. They had to step out of the unit and smoke outside. Some of you will call us and tell me, oh, I have been smoking for a while and my landlord hasn't said anything, so I'm grandfathered in, right? Well, that may not be true. It all depends on what the landlord wants to do. If the landlord can prove that they have given you warnings about not smoking, even though you are grandfathered in, you may be evicted. So please pay attention. Comply. No smoking on balconies, not inside the unit, not on common areas, not on halls. You have to step out of the building and smoke 6 meters away. You might be doing a good thing if you call the city of Abbotsford and you find out what their smoking bylaw says and comply by it. Also, under the umbrella of quiet enjoyment, tenants are supposed to be free from illegal landlord entry. A landlord must give a minimum 24-hour notice, but not more than 30 days written notice. No text messages, no emails, no phone calls. It's a written notice as required by law. The law doesn't say a text message is okay or that an email is okay. It's a written notice stating the day, the time, and the reason for entry. A lot of people get upset when I say written notice, and then they still clarify and say, do you mean the landlord has to give me a piece of paper? The answer is yes, they should. There's an exception though, and that is when there is an emergency and the landlord needs to get in. As you already know, all landlords in BC have an extra set of keys to our unit because of this specific situation, emergencies. Landlords need to come in because it is necessary to protect life or property. Examples of emergencies can be floods, fire, water leaks, etc. Landlords have an obligation as well to do repairs. Their responsibility is to comply by making repairs to the tenant's rental unit to ensure compliance with the health, housing, and safety standards required by law. Most of the time, these requirements are contained on what we call standards of maintenance by law. There are cities that do not have them, but if they, for example, think that they have to comply with something specific, then it is always good for the tenant to double check with the city. So for example, basement suites. Basement suites are very common in Abbotsford, but that doesn't mean that the owner of that house and that basement suite may be allowed to rent it out. Under residential tenancy law, basement suites are protected under Residential Tenancy Act, but there are specific guidelines by the city. So for example, a landlord may not be able to rent a basement suite because that basement suite doesn't comply with construction standards, or that basement suite does not comply with zoning bylaws, or that basement suite does not have a license. So these are three things that you always have to ask if you are applying for a basement suite. Is it within the zoning bylaw? Does it comply with construction standards? Do you have a license to rent it out, etc.? So some landlords who are very clean will show the license directly. So they still need to comply with repairs, need to comply with the health, as in there shouldn't be any infestations. And if there are infestations, the landlord has to pay for treatments. The tenants have an obligation to report. Housing is construction and safety standards required by law, doors, windows, and anything that would give access to the tenancy, to the tenant, to the rental place are under law. They are required by the residential tenancy branch plus the city bylaws. The policy guideline that helps answer more specific questions would be policy guideline number 1 on responsibility for residential premises. And as I said before, municipal standards of maintenance by law pertain to the cities. So cities should have them. If they don't have them, then probably you would have to try to enforce through the RTB. There's no other way around that. Then tenants' responsibilities also is a big part of a tenancy. Tenants are not only supposed to pass on problems, but they are also supposed to maintain reasonable health, cleanliness, and sanitary standards. In Abbotsford, there is a little bit of a problem of people who clutter and people who also hurt, that they herd, and also they are herding and hoarding. I'm sorry, herding, not hoarding. And so some others who are accumulating a lot of stuff, and then they don't want to get rid of it, and then their space is limited. So this is a mental disability, and they also need to get in touch with people who can support. Now, there are also services that may be available to you. You just need to call the city. So for example, the city of Vancouver has a service that offers support for people who hoard. So then people who are hoarding may be able to get rid of certain things if a landlord gives them a warning about hoarding and that they may be evicted if they don't comply. So you might want to connect with the city of Abbotsford to find out if they offer a service like that. And so please be aware that if you are a tenant and if your guests of your pets damage something, you are responsible for that damage, not the landlord. But that doesn't include reasonable wear and tear, which is the natural deterioration of the unit, your everyday use and everything you do in the unit. Do not withhold rent and apply for dispute resolution if your situation is not being solved. So the obligation of the tenant would be to report to the landlord. It is the obligation of the tenant to let the landlord know as soon as possible. If you delay, your problem could get worse and you could be held responsible for that payment of the repair. So it is in the best of the interest of the tenant to report to the landlord immediately. You can visit our website at tenants.bc.ca, go under resources and click on template letters and use the type of letters we have there for you to address your issues. Our popular letters are loss of quiet enjoyment, repairs and services, illegal eviction notices, illegal rent increases, bedbugs and infestations, and more. And so then all you need to do is just explore further and try to find a solution to your problem. So, and the most important thing, when something needs to be repaired, you need to notify your landlord immediately, preferably in writing, no text messages, no emails, no phone calls. It's a proper letter. And keep a copy for yourself for your records. That is going to help you create evidence and be protected. Also, emergencies is another type of thing that could potentially happen to you. Remember what happened in 2021 when the Fraser Valley was flooded? So a lot of basement suites, not only basement suites, but ground units also suffered. So in that case, for example, that was an emergency repair, urgent and necessary for health or safety of people or property. And so you have to know the list of emergencies under residential tenancy law. Major leaks in pipes or roof, damage or blocked water or sewer pipes or plumbing fixtures, primary heating system, damage or defective locks, and electrical systems. So all of these is your right to request for an emergency repair. And the protocol to be followed is that if a landlord's emergency contact cannot be reached after 2 tries and a reasonable amount of time has passed, the tenant can pay for the repairs and get money back from the landlord. So be reasonable and keep the receipts, or apply for dispute resolution to ask for an emergency repair order. So what you have seen here, it's always the landlord's responsibilities. Elevators is the responsibility of the landlord's. Heat is the responsibility of the landlord. Plumbing issues is the responsibility of the landlord. Infestations and other pests is the landlord's responsibilities, as well as defective locks, floods as well. And so then all of this is things that you as tenants need to be aware of. Landlords also offer essential and non-essential services. For example, essential services are heat, hot water, and elevator in multi-story apartments. Um, and so a landlord is not supposed to terminate a service or facility that is essential to the tenant's use of the rental unit. If that happens, you probably need to call us to discuss further about your options. And landlords are not allowed to terminate or restrict a non-essential service. Landlords are allowed to terminate or restrict non-essential services. So non-essential services can be cable, internet, parking, and storage. And so believe it or not, parking is not an essential service, but it can be part of the tenancy agreement. It may be included in your tenancy agreement. It may be free, or you will have to pay for it. But if a landlord wants to terminate a service that is non-essential to you, they have to give us a 30 days written notice in the approved form and to reduce the rent by an equivalent amount. So all of this is important because when you experience situations such as my landlord is doing repairs and I cannot use the kitchen, that calls for a reduction of rent. My landlord is repairing the washroom and I cannot use it, that calls for a rent reduction as well. All you have to do is write a letter to the landlord and inform him about your rights. Copy for them, copy for you. You can also see these letters on our website. Then we will address the part of rent increases. Rent increases happen every year for month-to-month renters. If you are locked in a year contract, your landlord is only allowed to increase your rent after the contract ends. And then if you roll on to month-to-month, or if the landlord is saying that he would like you to sign a new contract, or he just allows you to go month-to-month. The tenant's right is to go automatically on a month-to-month, and the landlord cannot stop you from doing that. There are tenants who also want to have another contract, but you cannot force your landlord to give you one. It is up to them. So all of this is important to remember, as many tenants get angry when we explain that the landlord is under no obligation to sign another contract with you. The law allows the tenant that after the contract ends, they can go month-to-month. And so then if at that moment you receive a 3-month notice, then your rent is going up by the amount set by the government. For the year 2024, the rent increases are at 3.5%, but the landlords are still mandated to give us a 3-month notice on the approved form and increase the rent to that amount. Now, there are cases where a landlord would ask for an additional rent increase, but that additional rent increase sometimes becomes a threat to the tenant. Let me explain. So we hear the following on the phone. My landlord is saying that his mortgage is going up and that they cannot do my tenancy anymore because I'm paying very low rent. And instead, he's asking me to agree to an additional rent increase of about $500. If it is true that we tenants are the wallet of landlords, it is also true that we are also experiencing hardship. So just by a landlord saying, oh, I cannot pay my mortgage, they know we are their wallets, but that doesn't mean that we tenants will be okay with paying an additional rent increase. We sometimes are barely feeding ourselves. We sometimes are barely paying basic services. And so this is a reality that we are facing after COVID. However, a landlord does not have to force you to accept an additional rent increase. Instead, they will give you a no-fault eviction under a landlord's use of property. If that is the case, landlords should be reminded that there are penalties for them if they are acting in bad faith and if they don't comply with what they say they were going to do. So, and there are also rental increases. The standard, which is the 3-month notice, plus comply with the amount set by the government, additional rent increase that have been accepted with the tenant and the landlord. They still need to give us the 3-month notice. If it is more than the 3.5%, then they still need to clearly reflect the amount and the percent. Also, there are some exceptions, such as nonprofit housing, where rents are related to income, whether if it is a nonprofit housing subsidized by BC Housing or BC Housing by itself, then they go on a different assignment for rent payment. Tenants mostly contribute 30% to the rent, and then they are subsidized. And yet, if you rent in a nonprofit, you might want to remember that nonprofits can do 2 yearly reviews if they want to, and still assign the rent accordingly to what BC Housing may have provided as a subsidy, or they may ask for more. And so then this is important to remember, because a lot of people believe that every place they rent is BC Housing's property. That is not the case. There are cases where there are nonprofit centers that provide the housing, and then they get paid partly a subsidy from BC Housing, but they go by the rules of the nonprofit. So it's key you remember that. There are also rent increases if a term in a tenancy agreement says that if you bring an additional occupant, your rent is going up, as well as if there is a residential tenancy branch order stating that your rent is going up for a specific reason. An example for that would be landlord's expenses. They can request for an extra rent increase if they can prove that their expenses have changed, and then they need to pay them to improve the building or the complex. And there's also capital expenditures, which is additional rent increases when the landlord wants to change important systems such as a boiler, for example. So all of these you can read on the residential tenancy website if you want to learn more. Now, I have been talking about written documents, and I have been talking about the importance of following the residential tenancy branch rules. They are very inflexible, the residential tenancy branch, and sometimes we have read decisions where the arbitrators decide to take the side of the landlord if the service of documents is not done properly. So there are rules that determine when a document is legally considered received by another party. And so if you give the document in person, it is received on the same day. If you fax it, attach it to the door, or left it in the mailbox, it is received 3 days after. Now, I will refer to the email link to an address provided for service. I mentioned this before. If you and your landlord have agreed to sign document 51 that you will accept email service, and I emphasize it, email service, then you will be fine. But if you have a correspondence via email with the landlord and that is how you correspond, that doesn't make it safe for you. And so, and then it's important for you to understand that emailing it to an address provided for service is something that you need to agree upon with the landlord, and vice versa, with the landlord and the tenant, and the tenant and the landlord. And so when you receive a document, you may want to consider it received the same day to be safe. And here's the part where I talk about text and social media messaging. Now, for forms and notices that need to be served in writing in accordance with the RTA rules, hard copy documents should be used. And I cannot emphasize this enough for you to understand that you could be in danger if you don't follow these rules that I just mentioned before. Now, a landlord should not send an eviction notice using social media, and a tenant should not text notice to move out. For general correspondence, text and social media may be okay if it can be proved that the other person received it. And at the end of the day, it all depends on the arbitrator to decide if they accept that as evidence or not. So you cannot think that you're going to be safe. Try to still do your due diligence by writing documents, keeping copies, instead of emailing or text messaging. So for example, a text message to or from your landlord talking about repairs may be considered valid evidence at dispute resolution, but again, I emphasize, it is at the discretion of an arbitrator. You cannot assume you're going to be safe. Now, you have been successful in renting for a while, and now you're about to move out, okay? So if you are about to move out, you need to follow specific rules. If you are a month-to-month renter, you are to give 1 full month notice to move out. So please look at the calendar there. You're moving out on September the 30th, so you must give notice prior to the payment of rent, which is 1 week or 2 weeks prior to the first. If you give notice on the first or the second, you may have given wrong notice, and now you still can move out for September the 30th, but the landlord is going to ask you to pay for October's rent. So you might not want to do that. You just follow the rules, which is 1 full month written notice. And that full month notice is on the month you move out, which is September. From the 1st to the 30th, that's your full month. So you have to give notice prior to the payment of rent on the 1st and on the month you want to move out. If you give notice the last 2 weeks of August, you also need to consider this method to serve documents. Follow those rules, you will be safe. People get angry when I explain this, and people get angry and think that they are right, but no, you are not, especially if you don't follow the rules. And so residential tenancy branch is one of the most inflexible government offices, especially when it comes down to serving documents. So please be aware. Give notice at the end of the month and leave extra days to ensure the notice is received on time. And remember, the tenancy ends on the last day and you do not have the full day to move out. Under Section 37 of the Residential Tenancy Act, all tenants must be moved out by 1 p.m. on the last day. And so then just please follow those simple rules, which is giving proper notice prior to the payment of rent. Preferably do it in writing, don't do it verbally, don't do text message. Remember these rules. If you give it in person, it is received that day and you always keep a copy. If you fax it, attach it to the door or left in the mailbox, make sure you bring a witness, make sure to take photos, and make sure you also keep a copy. And if you do email, you have to sign RTB number 51 for an address of service for email service. And if you mail it via ordinary or registered mail, it will be received 5 days after having mailed it. So pay attention to those rules and you will be fine. Then talking about fixed term tenancies is breaking a contract. So breaking contracts is not an automatic right for tenants. So tenants cannot assume that they are going to be safe just because they want to break a contract. I understand that tenants do have valid reasons to break a contract. However, that is the power of the landlord to allow it. And under residential tenancy law, there are specific rules about breaking contracts. So if you are a contract renter and there are 8 months left in the contract, you are in a very good position to offer assignment or sublet. But you still need the consent of the landlord. So you cannot automatically believe that you will be safe. 1, read your contract. 2, see the conditions of your contract. See if you have liquidated damages or any penalties that are going to work against you. And 3, make sure you get consent of the landlord to either assign or sublet. Residential Tenancy Law, Section 34 of the Residential Tenancy Act clearly talks about this. Assignment and sublet can be allowed by the landlord's consent. The landlord cannot withhold his consent if there are 6 or more months left in the contract. So that only tells us that if there are 4 or less than 5 months, you cannot get your contract broken. So what you need to do is read your contract, find if there are any penalties, comply with the consent, and you can do assignment and sublet. Assignment is when you abandon the contract and don't come back. If you abandon the contract, make sure to sign a mutual agreement to end tenancy. If you sublet, it means that you still want to go back to the contract, you're going to travel, you still need consent, and you want to go back to the contract, but you don't want to lose that contract, so you ask permission for a sublet, which is a temporary thing. It's not a permanent thing. And so, we always educate tenants about this. Breaking your lease, you may have to pay money to your landlord for loss of rental income, liquidated damages as well, or any other penalties the landlord may have included in an addendum or as additional information. So please read the contract. And if your landlord wants money for lost rental income, they have a duty to mitigate. That means that they must show the rental unit to prospective tenants, advertise at a reasonable rent, and accept a reasonable tenant. And some of the reasons that are allowed under legislation are assignment and sublet, a mutual agreement to end tenancy. If the landlord is not complying with a specific term in the contract, then they may the tenant may use that as a breach of a material term. So, for example, not providing heat, not providing water, not provided services under the contract may be a breach. If you are a tenant who is experiencing family violence, or if you are a senior who is going to long-term care and you want to get out of the contract, there is something called ending a fixed-term tenancy confirmation statement that you can get signed by a third-party verifier. That can be a professional, a qualified professional under the list of the regulations. You might want to call us about finding that list, or you can do your research and then check the residential tenancy regulations to find out the list of approved third-party verifiers. Please be aware that if you sign a mutual agreement to end tenancy, that can also be contraproducent to you. So before you sign anything, talk to us. As the mutual agreement, tenants and landlords are under no obligation to sign it. So you definitely might like to work that together with your landlord and vice versa if you are a tenant. You don't have an automatic right. But one piece of advice, not advice and probably information because I'm not a lawyer, but information that is pretty valid and hasn't changed is that a landlord cannot give you a mutual agreement if they want to evict you. Never accept a mutual agreement. And if they give you a document and are trying to force you, please read the yellow part, which doesn't show here, that says, neither the tenant nor the landlord are under no obligation to sign it. And instead, call us, talk it over with us, and explain as to why the landlord wants you to sign that mutual agreement. Sometimes the landlord says, my brother is moving in, my family is moving in. Please fill out this form. You don't have to sign it. Then we go to the part of returning the money. I had emphasized that you gotta do your inspection report together with the landlord. It's the landlord's obligation to offer you two opportunities, fill out the document, give you a copy. So the first step is do your inspection. Second step, on the day of the final inspection, the tenant gives forwarding address in writing, as tenants have a window of a year of the end of the tenancy to do that. So we strongly recommend that you provide your forwarding address on the day you do the final inspection and keep a copy for yourself. Landlord has then 15 days to do 3 of the things that we show here. 1, return your deposit within 15 days. 2, get your permission to keep some of all the deposit. Or 3, apply to the residential tenancy branch for permission to keep some, all, or more of the deposit if there are damages beyond normal wear and tear and the landlord can prove them. So the importance, I would like to emphasize the importance of doing the inspections. And also I would like to emphasize the importance of the landlord giving you these documents, the importance of tenants taking photos, the importance of tenants taking videos, because landlords are just, they just want to scam us of our money. If they see a little scratch, they think that they can keep all the money. That may be natural wear and tear. So it is always good to document. Okay, so I strongly suggest for you to be smart that way. Take photos, follow the rules of cleaning as per policy guideline number 1. If the landlord has not given you one list, then comply with policy guideline number 1. That will clearly help you out in the sense that it's going to clarify what you must clean up and how you must clean up: walls, carpets, nails, fridge, appliances in the place. Okay, so all of this is pretty important to remember. It's under policy guideline number 1. And so I will repeat the steps. 1, do the final inspection, document properly. 2, the landlord has an obligation under the first step of doing the inspection, the landlord must give you a copy of the document. Number 2, give your forwarding address in writing on the day you move out. Number 3, the landlord has 15 days to return that money to you once they have received the forwarding address. And so if the landlord doesn't follow the rules, then the tenant can apply to the residential tenancy branch for double the deposits. We have seen some tenants have been successful when they have asked for this, so we encourage you to use your rights properly as well. I know this is a lot of information, and I appreciate you staying put and staying with me on the presentation. So right now we're going to address evictions, which is a big headache for all tenants in BC. We may be an excellent tenant. We may be tenants who pay the rent on time and in full. We may be people who are very quiet and keep to ourselves. And yet the landlord can ask us to move out for a specific reason. They still need to have a valid reason. A valid reason for us to be evicted is not just a reason, a random reason. They still need to give us a proper reason to be evicted. Eviction number 1, a 10-day notice for non-payment of rent and utilities. You may receive a 10-day notice if you are only 1 day late or a few dollars short. The landlord does not have to accommodate your delay nor your lack of money. You sign a contract, and that contract clearly says that you must pay your rent on time and in full on the agreed date. And so then the moment you are in arrears or you are late, right, the landlord can give you a 10-day notice, and you only have 5 days to resolve. That's the technical name of the eviction. It's called a 10-day notice for non-payment of rent and or utilities. So when you receive a 10-day notice, you only have 5 days to pay up or apply for dispute resolution to cancel the eviction or try to resolve in a timely fashion manner. For the 10-day notice, the situation can get out of control if you don't do anything and don't challenge or don't pay. You don't find a solution, then it can potentially become even more stressful, and you could get an order of possession when the landlord goes to the residential tenancy office and they ask to get an order to get you out on the 10th day. It can be earlier. It all depends on how fast the landlord wants you to move out, and how fast they want to move on to get you out. So you might want to pay a little bit of attention to that. When you get a 10-day notice, make sure that you know what to do. We're telling you, you have 5 days to resolve, okay? If you can't resolve, then pretty likely the landlord can proceed to do the OP, and that is really stressful. So we strongly suggest for you to do the proper thing, call us, look for an answer. And again, the local advocacy in Abbotsford is Archway Community Services. They can also assist you if you have an inquiry regarding your non-payment of rent. Number 2, 1-month notice for cause, different reasons. The most common reasons for these are when you are repeatedly paying rent late. It can be 1, it can be twice, it can be 5 times in a row. It can be one isolated time 5 years ago, 2 years ago, or continuously. Violate another tenant's right to quiet enjoyment, damage something and do not help repair it, assign, sublet, or add an occupant or roommate without consent, fail to comply with a material term and ignore the landlord's written warning, engage in illegal activity that negatively affects the building, landlord, or other occupants, and receive a government order telling you to move out. Illegal suites. I have already explained that illegal suites are still covered under the Act, and that may be a reason for a landlord to evict you, especially if the city comes down and then says, oh, you have an illegal suite, you need to close it down, or we will give you a fine. And so then the landlord is pretty likely to get on it immediately, give you the 1-month notice, and off you go. Illegal suites, as I said before, are still covered by the Act. However, if an illegal suite is discovered by your city, it may be shut down. And so if the city orders you to move out, your landlord is required to give you a 1-month eviction notice, but no compensation will be given to you. Because the landlord is making you homeless, you might think, well, I'm entitled to payment, not under residential tenancy law. You may want to try that if you have a very extreme case, but you'll have to make a case at the residential tenancy office where you can prove that you have been homeless for a number of months or number of years due to the actions of the landlord and due to the inability or compliance with the city. Number 3, 2-month notice for landlord's use of property because your landlord or the close family member decide to move into your place. This is a very specific definition of a close family. It's landlord or the landlord spouse, parents or children of the landlord or the landlord spouse only. So when you hear your landlord saying, my mother-in-law is moving in, it is legal. Okay, but if they say my aunt or my uncle or my cousin is moving in, that is not within the definition of close family member under residential tenancy law. So all of these notices have a time frame to dispute. A 10-day notice, you only have 5 days to dispute. A 1-month notice, you only have 10 days to dispute. And a 2-month notice, you only have 15 days to dispute. And all of them can go for an order of possession. If the landlord decides to handle this to get the tenant earlier, they may be able to do it. Number 4, a form of notice for landlord's use of property for demolition, conversion, repairs, or renovations. You may get this notice if your landlord wants to demolish your rental unit, convert the property into non-residential use, convert the property to strata lots or cooperative housing, convert your rental unit for use by a caretaker, manager, or superintendent of the residential property. So you have to be careful with this. Now, there is an update on residential tenancy law for renovations and repairs. If your landlord wants to try to evict you because they want to make major renovations or repairs that require your unit to be emptied for an extended period of time, there are some requirements they need to comply with to give you a form of notice for renos and repairs. The requirements are: the landlord intends, in good faith, to reno or repair the rental unit and has all the necessary permits and approval required by law. The renos or repairs require the rental unit to be vacant or empty. The renos or repairs are necessary to prolong or sustain the use of the rental unit or rental property, and the only reasonable way to achieve it is through vacancy. And so then the landlords are not allowed to serve you an eviction notice. They have to apply to the RTB through a dispute resolution hearing. They must convince an arbitrator that they have the permits in place and that they actually intend to do these rentals. So that is approved by an arbitrator. And so it's not as easy as just printing one off and here you go. Sorry. Now, for the form of notice for landlord's use of property, there are a couple of questions to consider because sometimes there are situations where a landlord may accept or allow a tenant to accommodate some renters to avoid eviction and continue their tenancy if the tenant has no place to go. There's a common case that allows that. But there are some questions you need to ask. How extensive are the renters? How long will the unit be vacant? And how much of the unit will be affected? This case allowed the tenant to stay put in the unit at a very limited space. But this tenant did not have another place to go and could not secure a place. And so common law allowed this tenant to stay put, and she was successful. And once she was ready to move out, her tenancy was extended. So then you still can negotiate directly with the landlord. Okay. And so when you receive a form of notice, you have 30 days to dispute. For the 2 and the 4-month notices for landlord's use of property, if a tenant receives a 2 or a 4-month notice, they get compensated for 1 month of rent. So you can either live there for free for the last month, or you may withhold and then don't pay your rent, then you still can live there for free, right? If you wanna move out earlier before the 2 months are up, you can do that. If you are a month-to-month renter, not a contract renter, you are allowed to give a 10 days notice in writing and still be compensated for the last month. But again, I emphasize this is only allowed for month-to-month renters, not for contract renters, okay? It's key you remember that. Sometimes tenants believe that because they are in a contract, they are allowed to do it, and the legislation clearly says that it only allows it for month-to-month renters. If you're in a contract, your contract still has to be honored, and you cannot use the 10-day provision, okay? And so if your landlord lied about the reason for eviction, there are penalties for them. And that penalty could be a 12-month compensation for the tenant, okay? So the burden of proof is on the landlord. It means the landlord needs to prove why they couldn't move in and convince the arbitrator, okay? So today, for example, we have very good news. One of our advocates won a case for a 12-month compensation because the landlord could not convince the arbitrator about the reasons he had for not moving in. So you have to be careful and then follow the rules as much as you can. Now, for tenants who live in buildings who have 5 or more rental units, and tenants are being evicted for repairs or rentals, they have the right of first refusal to return to their homes once the rentals or repair have been completed. Only there is a catch. The limit on the rent, there's no limit on the rent. You cannot go back to the same rent, but you can put it in, and the tenants must provide Form 28, exercising right of first refusal. And then the landlord has an obligation to provide the tenants with a 40-day notice, informing that on the date the renovated unit will be available, and provide them with a new tenancy agreement for that effective date. But the only difference is that no limit on the new rent. Obviously, it's a new contract, it's renovated, so now the tenant has to pay more rent. And if a landlord doesn't follow through doesn't follow the right of first refusal rules, they could end up paying the tenant 12 months of rent as compensation. Okay. You could also get a 2-month notice for landlord's use of property when the property has been sold. Now, I need you to pay attention to the last bullet, where it says, the seller can issue an eviction notice on behalf of the purchaser if the purchaser or a close family member plans to move in, and all of the conditions of sale have been satisfied. In other words, a landlord cannot just a landlord cannot issue an eviction notice simply because they have put a rental property up for sale. They actually need to have sold it. And when a tenant rental unit is sold, the existing tenancy agreement transfers to the new owner if the new owner is planning on not moving in, but buying that property as an investment only. So the new landlord, if they are not moving in, they cannot offer a new contract as the tenant already has an existing tenancy agreement, a security deposit, and all of the conditions of the contract remain the same. I have been talking about the time frames for dispute. If a tenant does not think they deserve to be evicted, they can challenge the eviction notice at dispute resolution. And so for a 10-day notice, you only have 5 days to dispute. For a 1-month notice, you only have 10 days to dispute. For a 2-month notice, you only have 15 days to dispute. And for a 4-month notice, you only have 30 days to dispute. And so this is always key for you to make a case if you think that you have the grounds to fight it. Sometimes tenants feel that they are being evicted in bad faith, but sometimes proving that bad faith becomes a challenge. Okay, so we strongly suggest for you to get your ducks in a row and then finally decide if you really want to do it. sometimes there are situations that probably will take the side of the landlord, such as I am moving my family in and they mean it for good, they are serious about moving in, then the tenant will always lose. But if there are if there's evidence, for example, that you can sustain that your landlord is evicting in bad faith and that landlord is actually lying because they want more rent and because they don't get their way, then they evict you with a 2-month notice, by all means, go and fight it. And so I have been talking about the eviction process and the order of possession. In order to complete physically removing a tenant, an order of possession is supposed to be granted by an arbitrator. Landlords go to the residential tenancy branch after having given an eviction notice. The tenant has the right to dispute that notice, and if they don't use that right, then the landlord can go for an order of possession. It's a 48-hour notice. That's a 2-day notice where the tenant would be put under a stress test, in the sense that the landlord is going to push the tenant out with an order. Now, at that point, when a landlord gets an order of possession, they are not allowed to physically remove the tenant. The landlord must actually follow the next step, which is get an order. It's called a writ of possession by the Supreme Court, and hire the services of a bailiff to legally and physically remove that tenant. Okay, so in that case, then when you get at that point, we won't be able to assist you. We cannot assist you at the order of possession. We cannot assist you at the writ. We cannot assist you when they physically remove you as an end of the process. There are, though, some other recourses. If you want to challenge a decision that you are not happy with, there are 2 steps you can follow. So say, for example, you lost your hearing for an eviction and you are not happy with that, and you feel that the arbitrator was biased, or you feel that the landlord lied. So then you have the recourse to do a residential tenancy branch review if you meet one of the reasons stated here: circumstances beyond individual's control, new and relevant evidence, and fraud. Okay, you just have to meet one. And then if that doesn't work and you end up losing, then you can move on to do a judicial review. Okay, and a judicial review is done at a Supreme Court level. You will need a lawyer for that. TRAC does help with that. But again, you have to come to us with a decision and recording of the hearing in order for us to consider your case. So we normally tell tenants, if you are planning on coming to us, bring a copy of the recording of the hearing plus the written decision. Our services are free of charge, and there are only 2 places that do judicial reviews, and that is our housing law clinic, where we have only 2 lawyers to do it, and the Community Legal Assistance Society, who only intakes evictions. Okay, and so then other than that, then we also help with monetary order enforcement at small claims court. So say you are a tenant who won compensation for 12 months because the landlord lied, then if our lawyers it's not a priority, but they can definitely get involved if they think the case is worth it. Last but not least, this is a summary of the tenant's responsibilities. Pay rent on time and in full, keep the rental unit clean, notify the landlord of any repairs immediately, responsible for any damage beyond normal wear and tear, don't unreasonably disturb others, and don't do anything illegal and dangerous. And this is a summary of all the things you saw in the slides. And also for the landlords need to provide a copy of the tenancy agreement within 21 days, provide 2 opportunities to complete move-in and move-out inspection reports and give us documents, provide a receipt for rent paid in cash. Section 26.2 of the Residential Tenancy Branch of the Act, clearly states that a landlord should give a receipt for rent paid in cash. If you're paying rent in cash and you know your landlord is not going to give a receipt, please go and get a book of receipts to make sure that you get all these register. If not, then it's going to be a hard time. Okay. And so make repairs to ensure the rental property complies with health, housing, and safety standards required by law, and return deposits on time. It doesn't say the landlord is allowed to keep the money, right? So you gotta make sure that have your pastillas? That the landlord does follow the rules. Okay, provide quiet enjoyment to tenants. This is a very important part of the tenancy. The tenants can definitely mess up if they don't follow the rules too. Okay, so again, you know you're paying rent in cash, but the landlord is not giving you receipts. Go and get a book of receipts and keep control of your payments, or find a way to prove that you have made your payments. Okay. Final thoughts: if you want to tell your landlord to stop breaking the law, ask them in writing. And always remember to think about gathering evidence, take photographs, get witnesses, keep receipts. And if you are unsure about something, ask for help. You can go to the local advocates in Abbotsford. It's called Archway Community Services. TRAC is also open Monday through Fridays. And again, we are open late tonight from 5:30 to 8:30. Every Wednesday, we are open late. So if you cannot call us on Monday, Tuesdays, Thursdays, and Fridays, do call us on Wednesdays. We are open 1 to 5. This is our contact information. If you want to reach out, that is our RentNet Right information line number and some other resources on social media. If you want to give us feedback, we ask you, we would really use the feedback for our funders as they want to see that we are doing our jobs. And that would be the first link, surveymonkey.com/r/SED We would appreciate your feedback. So I'm ready for questions, and over to you, Deanna.
Excellent. Thank you so much for all of that information. I'm going to stop the recording now and we'll go to the Q&A part.